The criminal charge of obstruction of justice in Louisiana can arise in many fact situations. However, it is always a felony charge with serious consequences. The allegations of obstruction of justice will fall into at least one category in the statute. Regardless of the provision it falls under, the prosecutor must prove it was committed with the knowledge that such act has, reasonably may, or will affect an actual or potential present, past, or future criminal proceeding. There are 4 provisions in the obstruction of justice statute that describe the ways the conduct can affect criminal proceedings to support obstruction of justice. First, it is tampering with evidence with the specific intent of distorting the results of any criminal investigation or proceeding which may reasonably prove relevant to a criminal investigation or proceeding. Tampering with evidence shall include the intentional alteration, movement, removal, or addition of any object or substance, either at the location of an incident where the perpetrator knows or has good reason to believe will be the subject of any investigation by state, local, or United States law enforcement officers, or at the location of storage, transfer, or place of review of any such evidence. And this is the most common provision alleged. For example, a defendant may try to destroy drugs while being pursued by a law enforcement officer. Another example is when a crime is committed with a vehicle and the defendant then burns the vehicle. The next form of obstruction of justice is the using or threatening of force toward the person or property of another with the specific intent to influence the testimony of any person in any criminal proceeding, cause or induce the withholding of testimony or withholding of records, documents, or other objects from any criminal proceeding, cause or induce the alteration, destruction, mutilation, or concealment of any object with the specific intent to impair the object's integrity or availability for use in any criminal proceeding, evade legal process or the summoning of a person to appear as a witness or to produce a record, document, or any other object in any criminal proceeding, or cause the hindrance, delay, or prevention of the communication to a peace officer as defined in 1430 of information relating to an arrest or potential arrest or relating to the commission or possible commission of a crime or parole or probation violation. This provision is usually alleged when the defendant has a trial coming up and knows that a witness testifying could cause a conviction. Therefore, he attempts to influence the witness not to appear. That is obstruction of justice. Third, retaliating against any witness, victim, juror, judge, party, attorney, or informant by knowingly engaging in any conduct which results in bodily injury to or damage to the property of any such person, or the communication of threats to do so with the specific intent to retaliate against any person for the attendance as a witness, juror, judge, attorney, or party to any criminal proceeding, or for producing evidence or testimony for use or potential use in any criminal proceeding, or the giving of information, evidence, or any aid relating to the commission of possible commission of a parole or probation violation or any crime under the laws of any state or of the United States. This one is pretty straightforward and in the sense that a person cannot retaliate against another for giving testimony. Fourth, inducing or persuading or attempting to induce or persuade any person to do any of the following: testify falsely or without right or privilege to do so, to withhold any testimony, or without the right or privilege to do so, absent himself from such proceedings despite having received service of a subpoena. Now, the penalties for obstruction of justice in Louisiana vary based on the type of charge and the underlying criminal proceeding. When the obstruction of justice involves a criminal proceeding in which a sentence of death or life imprisonment may be imposed, the offender shall be fined not more than $100,000 and imprisoned for not more than 40 years at hard labor, or both. When the obstruction of justice involves a criminal proceeding in which a sentence of imprisonment necessarily at hard labor for any period less than a life sentence may be imposed, the offender may be fined not more than $50,000 or imprisoned for not more than 20 years at hard labor, or both. When the obstruction of justice involves other criminal proceeding, the offender shall be fined not more than $10,000, and prison for not more than 5 years with or without hard labor, or both. That is a rundown on obstruction of justice statute in Louisiana. So feel free to check out my other videos for more information on Louisiana laws. If you need a defense attorney for obstruction of justice, feel free to give me a call. I'd be happy to help.